I have an extra copy for Joe. No. I am going to mark, but I've been asked that they be sealed. I don't know if you want to mark them now or.
I will prepare a sticker. You don't have to give it to me now if you want to wait. Okay.
I already Do you need
well, you know what? You can probably place it on the bench.
I'll just hand it to
Okay.
So I'm sure, I know that the media knows the drill on this, but just for everyone else, we do have pooled camera and video and still photography today by order of the judge. So that means that nobody else in the courtroom can use a cell phone or anything else to take video or camera for proceedings today. And this is just a good opportunity to remind everyone that their cell phones should have their sound off before we get started. Thank you. I will ask when I go back. You guys are all set?
I am going to ask some of my things to be sealed. We can discuss it outside.
Okay.
I wanted to see this one.
Okay. All right.
Ladies and gentlemen, please rise for the honor report. And the County Superior Court is in session.
Good afternoon.
For the record, this is the matter of State versus Owen Labrie, docket number 217-2014-CR617. Mr. Labrie is present, represented by his attorney, Jay Rayport. The state is represented by Deputy County Attorney Catherine Ruffle and Assistant County Attorney Joe Chininsky. The court has a hearing this afternoon on the state's motion to revoke bail.
Okay, I'll hear from the state.
Thank you, Your Honor. I communicated with Attorney Rayport earlier today, and we both agree that we are willing to present the evidence to you by way of offer of proof, if the court so pleases, rather than having actual testimony from the witnesses.
Okay,
If that pleases the court.
that's fine.
And also, as a matter of housekeeping, Your Honor, I apologize. I think I might have made things a little easier for you if I had attached a copy of the bail order to my motion, but I did not. So I'm going to ask the court to take judicial notice of its own bail order that was originally issued following the verdict on August 28, 2015, and then ordered to remain in effect following the sentencing hearing on October 29, 2015. And as I've referred to in my motion, Your Honor had ordered that there were specific conditions of the bail to include that the defendant was to reside and that he comply with the daily curfew. And it was the understanding that he was to be at his mother's residence during those time periods. As I've indicated in my motion, Your Honor, an investigation began following a series of Twitter messages that occurred on the internet, or were posted on the internet on February 29, 2016. And basically the substance of those Twitter messages that came from a reporter who had covered the defendant's trial here in August and recognized the defendant traveling on a train in Boston. She approached the defendant, they engaged in conversation, and then she posted information about her conversation with him on the internet. Among those postings, there was information, according to the reporter, that the defendant had traveled that day from his area in what was essentially, I believe that he referred to traveling from Dartmouth to Boston to visit his girlfriend at Harvard, and that he had taken a bus to Boston and now was commuting on the train. Following that information and calls to the county attorney's office, the state asked the Concord Police Department to conduct an investigation into the defendant's travels to determine if he was actually within the curfew that he had been ordered. Conceivably, it was possible, Your Honor, that he could have been on the train in Boston at that time without violating his curfew whatsoever, but because there were inquiries concerning whether or not he was in violation, we did conduct an investigation. If this were to go to a contested hearing without offer of proof, Your Honor, the state would offer testimony from Detective Julie Curtin from the Concord Police Department. She would testify that she began her investigation by investigating bus services from the Hanover, Lebanon area to Boston. She was able to determine that the defendant had indeed traveled from Lebanon, New Hampshire to Boston on the Dartmouth coach bus line. She obtained business records from the bus company that showed that the defendant had used that service to travel on 7 occasions between the dates of August 29th, when the first bail order was issued, August 29, 2015, and March 10, 2016. We would offer the business records into evidence, Your Honor, and the records would show the time that the bus tickets are purchased, how the bus tickets are purchased, for example, through cash or credit card, and the time that the defendant actually traveled. Detective Curtin also did a Google search to determine the distance from the defendant's home address to the bus station in Lebanon. She determined, based on that calculation, that it was approximately 30 miles and would take approximately 40 minutes for the defendant to travel from his home to the bus station and from the bus station to his home in an effort to determine the approximate times that the defendant was actually traveling, not just on the bus. She also conducted an interview with the keeper of records so that she was able to understand the information that was provided in those business records, and during that interview also learned that the credit cards that were used to purchase the tickets also contained personal information that identified the defendant, Owen Labrie, before the court as the actual person who purchased those tickets and was traveling, in case there was any issue in regard to the identity of the individual. Detective Curtin also interviewed 2 ticket sales employees from the bus company who were actually familiar with the defendant and also would testify that they identified this defendant before the court as the individual that we're speaking of. We are also able to obtain surveillance video from the date of February 29th, 2016, and that surveillance video shows the defendant purchasing a ticket and actually boarding the bus and shows the bus driving away. In addition to the travel records, Detective Curtin will also testify that she interviewed the reporter as well as the ticket agents who identified the defendant, and both the reporter and one of the ticket sales employees indicated to Detective Curtin that the defendant made admissions to each of them that he was traveling that day to visit his girlfriend at Harvard. And at this time, Your Honor, I would like to enter exhibits that have been marked by agreement as State's Exhibit number 1. And, Your Honor, if I may approach?
Sure. And I assume copies have been provided to you?
Yes, yes, and I did. As I said, she's in agreement that these could be marked as exhibits. And Your Honor, just for the purpose of clarity, I have a blow-up because I want to be sure that what I'm referring to on these schedules, you're clear about what I'm. Can you see this? So, Your Honor, from these business records, and we also have additional records, but this is sort of a summary of the records, we are able to determine that the defendant traveled on October 23, 2013. He purchased his ticket at 7:05 a.m. And again, remembering that he would have had to have left his house approximately 40 minutes prior to that time. So he would have had to leave his house at 6:15, 6:30 in the morning in order to be at the station in Lebanon to purchase this ticket. The ticket was for transportation to Boston, and just by purposes of information, Your Honor, it's my understanding basically that the ticket is issued and is blank and is not actually stamped until the individual provides it to get on board the transportation. The time that the bus actually departed was 7:20 a.m. We also are able to determine that there was a round-trip ticket that was purchased. The time of departure from Boston was 7:30 p.m. and the defendant would have arrived in Lebanon at 9:45 p.m., again arriving at his home at approximately 10:15 or 10:30 that night. On October 28, 2015, and I'll move through these a little bit more quickly, Your Honor, the defendant purchased a ticket at 5:06 a.m., left at 5:20 a.m., and returned that night on a 7:30 bus, arriving in Lebanon at 9:45 p.m. November 29th, he purchased a ticket at 5:05 a.m., departing at 5:20, and returning on a 3:30 bus, which would have taken him at an arrival time at 5:45 p.m. December 19th, there was a ticket that was purchased that was voided. We have information about that, but at this time I won't go into. For now, it's not relevant. On January 28, 2016, he purchased a ticket at 5:15 a.m., left at 5:20 a.m., returned later that day at 3:45 p.m. December 17, 2017, bought a ticket at 7:08 a.m., departed at 7:20, and arrived that evening at 11:45 p.m. On February 18th, he bought a ticket, and again this is 2016, at 5:07 a.m., departed 5:20 a.m., and arrived that night at 11:45 p.m. February 29th, 2016, purchased a ticket at 5:01 a.m., departed at 5:20, and arrived that night at 3:45 p.m. Pursuant to the investigation, Your Honor, we did later learn that the defendant had actually contacted pretrial services acting director Jim Moe and asked permission to extend his curfew on the dates of February 17th and 18th, 2016. So giving the defendant the benefit of the doubt on these dates, the 17th and the 18th, the state did not include those 4 violations of curfew in the motion that we filed. That's where the state came up with the number eliminating. The total number of violations of curfew are 12. We did not include the 4 that arguably the defendant could say that he believed he had permission from pretrial services to extend that curfew. That's where the state came up with the number in my motion, indicating that there were at least 8 violations. As recently as this week, we also had information that there was another occasion, and that was the 28th of October 2015, that the defendant had called into pretrial services on that day as well, indicating that he was meeting with counsel and he would be late. So again, eliminating those 5 violations, there are at least 7 violations of the defendant's curfew for which he has no justification. I would also like to point out, Your Honor, that although the defendant may have believed that he had permission from pretrial services, the defendant is not ordered to pretrial services supervision, and that was completely in error on their part. In general, when individuals are ordered to pretrial services supervision, their curfew is determined at the discretion of pretrial, and not really becoming fully cognizant that this individual was an exception to that practice. He was given permission, but without authority to do so. He is not on curfew at the discretion of pretrial services. He's on curfew out of Your Honor's court order, and it's a condition of his bail. It is not a condition of pretrial services supervision. Your Honor, it's our position that these are willful violations. The defendant can argue that on occasion there may have been a circumstance that caused him to be late, but there's absolutely no circumstance that would allow him to leave his home several hours before 8 a.m. in order to travel on all of these occasions. We have provided for you also in this exhibit, Your Honor, the actual bus schedule that shows if he wished, he could have traveled to Boston without violating his curfew. It is possible that he could have left at approximately 9:20 from Lebanon, arriving in Boston at 11:30 in the morning with a 2-hour window to return back, getting him home within the time of his curfew. Again, if he wanted to, but he chose not to. In response to defendant's objection to our motion,
I was going to ask you, if I'm sure you've had a chance to review it. I was going to ask you your response to that.
we have had an opportunity to respond to that, Your Honor, or excuse me, to review that. And it suggests that the state is erecting a barrier to the defendant's constitutional right to be defended by counsel. We absolutely agree that he has a right to counsel, but we disagree that it would be unreasonable to expect the defendant to ask permission from the court to violate his curfew in order to meet with counsel. We argue that there's no justification for refusing or failing to seek an order from the court for any amendment to his bail for a reasonable purpose or reasonable conditions. They didn't do that, Your Honor. They did do that in December of 2015 when the defendant wanted to travel to visit a sick family member. So based on that motion that was filed previously, the state feels that it was disingenuous for counsel to make a statement that the defendant and counsel believed that seeking permission from pretrial services in advance of travel was an acceptable mechanism for traveling outside the curfew. Clearly in December of 2015, it was evident that they believed that a court order was appropriate for him to travel. I also want to point out that the defendant admits that he's violated his curfew. He wants to ask forgiveness now because he failed to ask permission earlier. I also would like to point out that he has not been apologetic on any occasion up until now. Specifically, he's quoted in a Newsweek article speaking in reference to his trial, stating, "I do it the exact same way. It was the only thing that sustained me, knowing I had told the truth, I had done what was right. I walked out of the courthouse with my chin up." Your Honor, he lied to the jury. He lied to Your Honor. And now he's been walking around not only with his chin up, but with his nose up in the air, snubbing Your Honor's court order. The defendant is not above the law. The rules apply to him just as they do to others. He agreed to these conditions. In fact, his counsel suggested that the conditions should remain in effect at the sentencing hearing. And Your Honor, I have a transcript of the sentencing hearing, and at that time, Mr. Carney said to Your Honor, "May I suggest that the very strict conditions that you imposed after the verdict, in which he has complied fully, be reinstated for this period." He had not complied fully, Your Honor. These two occasions, October 23rd and October 28th, were prior to the sentencing hearing. The state was not aware that he was not in compliance, and we would have brought that to the court's attention at the time. It was not until this investigation that we were aware that he had already violated his curfew when we were arguing at the sentencing hearing. And I also would point out that Your Honor has put the defendant on notice. At the sentencing hearing, Your Honor told him, "It would be very foolish of you, and you've done some foolish things in this case. I'm not going to put it beyond you to do something foolish, but it would be exceedingly foolish if you do anything in terms of violating your bail conditions." If the conditions had created a hardship for the defendant for any reason, it was his obligation to seek an amendment by court order. Simply, he hasn't done that. He's been moving about the New England states as he sees fit. Again, Your Honor, I would point out that these are willful violations. The defendant wants to seek forgiveness at this point, and the state is asking you to hold him accountable.
Thank you, Ms. Ruffle. Ms. Rancourt?
Thank you, Your Honor. May I approach and
Of
provide
course.
you with some exhibits? Yeah, for now,
Okay, Jane, if you wanted to comment.
when I get to it. Your Honor, I've outlined the bulk of my argument in my objection, but let me go through them more specifically for you, and I'll also take you through the exhibits. As stated in our motion, meetings on October 23rd and October 28th, the first two violations noted on the chart provided by the state, fall under this court's previous bail order, which is superseded by the later bail order because the later bail order is granted under other conditions, under other section of the statute, because it falls under after sentencing, not pre-sentencing. But, so I think that it's outside the parameters because it's a different bail order. But both of these days were meetings with J.W. Carney. Exhibit A, attached in your binder, is a letter from J.W. Carney, attorney J.W. Carney, who provided us documentation indicating that both on October 23rd and October 28th, Mr. Labrie was with them in their office in Boston for previously scheduled meetings. As the state has outlined, the only way for Mr. Carney to get from his home in Tunbridge, Vermont, to a meeting in Boston.
Mr. Labrie to get from his
I'm
house.
sorry, did I say Mr. Carney? The only way for Mr. Labrie to get from Tunbridge, Vermont to Boston on the bus line would be for him to catch a 9:20 bus from Lebanon, 2 hours to Boston, possibly more with traffic depending on the time of the morning, gets him into Boston at 11:30, and he has to get on a 1:30 bus to leave Boston in time to make his curfew. That's a 2-hour window of time, assuming that 2-hour window of time fit into Mr. Carney's schedule, that he had to meet with his counsel. That's very restrictive, and pre-sentencing was unreasonable given the amount of time that they had to spend together pre-sentencing. The next exhibit attached for you at Exhibit B is a series of emails between Mr. Labrie and Danya Fullerton, who is an attorney in Mr. Carney's office. The email exchanges on October 20th, 2015, and we would present evidence if we had to call witnesses to say that Danya Fullerton, an attorney in Mr. Carney's office, was communicating with Mr. Labrie about notifying pretrial services about this meeting on October 23rd and asking for permission for Owen Labrie to travel outside his curfew so that he could meet with them in their office on October 23rd. Danya Fullerton confirms via email that she is going to notify pretrial services. I understand Merrimack County Pretrial Services does not have a notation of that in their file. They didn't note that when the state went and looked at their file that permission had been granted from pretrial services that day, but Attorney Fullerton had communicated to Mr. Labrie that she was going to do that, and that was Mr. Labrie's understanding when he traveled on October 23rd that had been permitted. I'll turn to Exhibit C in that binder. Exhibit C are documentations from the Merrimack County Pretrial Services Office. While they don't note this meeting on the 23rd, they were notified of the meeting on the 28th. It is noted in their documentation that they were notified that he was in Boston meeting with counsel. It was, again, Mr. Labrie's understanding that Mr. Carney's office was communicating with pretrial services about their meetings both on October 23rd and October 28th, and that travel had been previously permitted by pretrial services. After the first 2 pages of notes under Exhibit C, you'll note the state head of pretrial services pull the call-in history for all of these dates listed. You will note that on all of these dates listed, Mr. Labrie did call in, although the time varies. The curfew for everybody else listed on this page from pretrial services is 7 p.m. to 6 a.m. daily, probably with some understanding that...
Wait a minute, are you saying on all the dates specified by the state or all the dates in the exhibit?
All the dates specified by the state, which are all the dates in the... They had... So instead of every call-in date that Mr. Labrie ever made, what is attached is the call-in for October 23rd.
Does it document that he called in to ask for an extension of his curfew, or did he just called in?
This is the nightly call-in log.
The nightly
call-in.
call-in,
So when they call
okay.
in, they note that he called in and what time.
Okay, so there's nothing in here that says that when he called in, he asked to extend his curfew?
No, those are noted on the first 2 pages.
That's what I thought.
Yes.
Okay, I just
Yeah.
wanted to just make sure that I understood the exhibit.
Okay, sorry, yes. Starting on page 3 is, so the page 3 would be from the date, October 23rd, 2015, which was a Friday. Number 47 on their list is Owen Labrie, and the time that he called in that night. So that was a night when he was meeting with Mr. Carney. He called into pretrial services at 22:15. I did want to note, for your honor, when you see these call-in times, none of these call-in times are between 5 and 6. Reason for that, pretrial services doesn't even open their phone lines for call-in prior to 6 p.m. He has to call in. What they tell him is you have to call us between 6 and 8. That's when we open our phone lines for call-in, unless you're calling in late because you've told us you're going to be late, and then you just leave a message and when you get back. So he can't even call in at 5 o'clock because they don't supervise anybody else with a similar curfew to Mr. Labrie. Then I've also attached, for your honor, under our Exhibit D, the bus schedule showing that basically to get to Boston, do anything in Boston, and get back, he would leave him approximately a 2-hour window. And Exhibit E is MapQuest and directions from Lebanon to Boston to confirm that it takes at least 2 hours. The next exhibit, Exhibit F, may we approach on that exhibit?
Sure.
Exhibit F, Your Honor, is by way of explanation on the date of November 29th, 2015. Mr. Labrie did violate his bail in the morning by leaving on a bus at 5:20 to try to get to Boston, Massachusetts. The reason for his travel that day was to conduct research. I've attached a letter under Exhibit F for it, Your Honor. Mr. Labrie has been working with an individual on a master's thesis. The topic of that master's thesis is enclosed in this letter, more detailed information about what that would entail from Mr. Labrie. What it entails for Mr. Labrie is to travel to Boston to get primary source documents for this thesis project that he's been working on. The documents that he needs are not available through any other source other than certain libraries in the Boston area. And that's why he had traveled on that day, was to go to the library in Boston to research these documents. That evening, and that falls under Exhibit G, that evening Mr. Labrie attempted, or that afternoon I should say, to catch the 1:30 bus back to Lebanon that afternoon. And when he arrived at the bus station just shortly before 1:30, the bus had already left, and he missed the 1:30 bus, had to wait 2 hours for the 3:30 bus, and there was, the documentation of that essentially is a text message correspondence between him and his father, where he documents that he had trouble getting back that afternoon, and the trouble was that he had missed the 1:30 bus and had to wait for the 3:30 bus, which caused him to miss his curfew that afternoon. The morning violation, to leave that morning to go and to conduct research, I think I'm going to take some responsibility for this myself. Mr. Labrie and I had had numerous conversations about these bail conditions and the restriction on this bail conditions and the fact that it essentially caused him not to be able to do any schoolwork, not to be able to find any employment. Mr. Labrie lives in Tunbridge, Vermont. He could not find employment locally. His name is well known, and no one was willing to employ him or associate with him, quite frankly. So he could not find employment without traveling, and could not find employment within those hours. He could not, for the same reason, could not find schooling, and was essentially stuck in his home in Tunbridge, Vermont. We had reached out to the state and asked for permission to extend these hours out for employment and school. And their response to us was they would agree to extend out for work with very specific information about where he was going to be working and what kind of hours he'd be working, and very specific, they would not agree to extend for educational purposes and suggested online courses at that time. Mr. Labrie and I did have conversations about that, and the hesitancy was this spectacle that occurs in the courtroom for Mr. Labrie. And I think it's also been documented with when Detective Curtin went to the bus station. When Detective Curtin went to the bus station to ask the lady at the ticket counter, I'm going to ask you about a ticket you sold to Owen Labrie, she knew exactly who he was talking about, exactly what day she had seen him. She knew Owen Labrie, she knew his history, and when she first met Owen Labrie, had a conversation with him about what he was accused of, what he had been convicted of, and his life. This is his life. If he goes to apply for a job, he's turned down because he's Owen Labrie and no one wants to be associated with him. If he signs up for classes and it's going to be known where he's taking classes, they won't accept him because they don't want to be associated with Owen Labrie. If he approaches a professor for working with them and they think that someone's going to find out that they're doing it, they won't do it. And Owen and I had had these conversations, and I had said to him, we're going to need to file a motion in court, and it's going to have to be public, and everyone's going to know that you're getting on a bus at 5 o'clock, where you're getting on the bus, where you're going, what time you're getting off the bus, who you're meeting with, what time you're meeting them. And that causes, quite frankly, danger for my client. My client has received death threats in the mail at his home. People approach him in public. He has gotten into physical scuffles with people who've approached him in public and insult him and want to physically assault him. telling the public, telling the media where my client is at all times is not safe for him. So he chose, wrongly, Your Honor, admittedly, to try to fly under the radar and on 3 occasions go to Boston early in the morning to try to pursue some academic endeavors on the quiet, without people finding out, and without it being ruined for him. And he's sorry for that. The next exhibit, my Exhibit H, may I approach about the next series of exhibits as well?
Yes.
Can you pull that microphone towards, yeah, towards the bed? That's great.
Very good.
It's up to you. If you want to take the recess, I'll give you that. If you think you can look at it, that's fine.
Could I just 5-10 minutes?
Sure.
All rise, please. Court's in recess. You may be seated.